Every day in the USA, people find themselves in court.
Mr. Sharp, can you hear me?
I can. Can you hear me?
Yes, I can. Obviously, you're at work. Looks like you're in some piece of equipment, a helicopter, a nuclear submarine.
I'm in my semi parked, Your Honor.
Okay, very good. Let me call the case. This is file 18712GC, Premier Medical Care versus Cody Sharp. Mr. Lee Melde from the Velo law firm is present, and Cody Sharp is here via Zoom. There was a judgment that entered in this matter. I had it in my hand a minute ago.
Correct, Your Honor. That was July of 2018.
In the amount of $4,127.35. I believe it was actually a consent judgment.
Your Honor, it wasn't 4,000, it was 400.
Your Honor, this was a default judgment.
Yes. Oh, now I'm maybe looking at the wrong judgment. 191343. Yeah, that's a different case. And I think that was what's going on. File 18712 is the case we're here on. And that is much less, 400. Trying to find that original judgment. This is an old paper file, and I believe it was a default in the amount of $484.94.
That's correct.
The plaintiff is still attempting to collect on this debt, and Mr. Sharp has filed an objection. It wasn't much of an objection, but I set it for a hearing. I'll read his filing. It's kind of blurred. I'm requesting a hearing on this matter. I paid off this account in the fall of 2019, as well as the fact that the Velo Law Office has violated the Fair Debt Collection Practices Act. So the defendant's contention is that he paid off this claim in the fall of 2019. Mr. Sharp, do you have any proof of that?
Unfortunately, Central Professional Services, which is the collection agency hired by Premier Medical Care, will not give me that information, but they are confirming that there's a zero balance on it. I've also contacted Premier Medical Care, who's also confirmed a $0 balance as well. I have also asked from Velo Law, and they have refused copies of the transactions on the account, including every payment, as well as every fee that has been charged. They have refused.
You're not required to.
Just a minute. What was the servicing company? Would you take your gum out? We're in a court hearing.
Sorry.
What was the servicing company?
Central Professional Services. They're the company that actually hired Velo Law Office.
Did you ever receive a satisfaction of judgment saying that the judgment had been paid off?
I have, but unfortunately, at the end of 2019, December of 2019, I went through a divorce, and a lot of the stuff that I had has been lost in the moves.
All right,
but
we tried to investigate this ourselves. Our clerk did a deep dive in this and came to the conclusion that we may be talking about a couple of different file numbers, different claims, but there is no satisfaction of judgment. So I set it for a hearing to have Velo explain their perspective. Mr. Velde, what's your position?
Well, Your Honor, there hasn't been a satisfaction of judgment because the judgment has not been paid off. The last payment that I see in our records is from March of 2019. And secondly, we weren't required to submit a statement once we got that writ for a periodic garnishment. There's a 6-month period from once we garnish in which we need to send a statement. That 6 months isn't up yet, so we haven't been required to submit a statement to the defendant yet.
What's the current balance?
The current balance after we received a garnishment payment on November 7th. So the balance is minimal as of right now. It's $2.11. But if the court grants the objection, the garnished payments prior would be returned.
Well, there is no satisfaction of judgment. Uh, Mr. Sharp has his representations of what happened. There's no evidence to support it. And the garnishment has essentially already swallowed it up. There were several accounts, and there was the other account I mentioned, which was in the $4,000 range, and I'm not sure what happened to that one. But this one, there was some payment, no payment made in 4 years. You secured the garnishment and have essentially paid it. So I find the objections, maybe they're valid, but I don't have any proof of it other than Mr. Sharp's impressions. I find they're invalid, and the garnishment shall.
Your Honor, not only that, they have violated the Fair Debt Collection Practices Act, because every time I phone them, they are supposed to read what is called the mini Miranda, that this
Not
communication is with it. Yes, it is. It is 100% true.
Litigation.
It doesn't
We
matter. You are an attorney.
Stop,
Well, first
stop,
off,
stop. I'll let you
let me
vent a little
finish.
bit. Go ahead.
Under federal law, according to the Federal Trade Commission, and I'm a former debt collector. I was a manager in a collections department of the 8th largest bank in the United States. I know the laws. Even attorneys' offices collecting debts have to say on every single phone call when they make contact, whether it's inbound or outbound, they have to say that this communication is with a debt collector and any information can be used for that purpose. Whenever I have called Velo Law Office, they have not said that statement. And every time that I call them and they don't say that, that is a violation of federal law. Okay? They have violated that.
I don't know what the harm is. You're very knowledgeable about collections. If they didn't tell you that, file an action in federal court, I guess, and you can deal with it.
It's also,
go ahead.
I was going to say, Your Honor, I don't mean to interrupt you, but that's not a valid objection based off of the Michigan court rules anyways. 3.101K2 states what needs to be in an objection, and that's not a valid objection to a garnishment. And like you said, if he wants to file a federal complaint, he can do that, but we did not violate any Fair Debt Collection Protection Act.
And what's the balance?
The current balance as of today is $2.11. The most recent garnishment was $243.46. So if, like I said, if the court does grant the objection, which I don't assume you're going to or don't hope you would, almost the entire amount would be returned.
All right. Well, I find the objections are not valid. The garnishee shall release all withheld funds to the plaintiff. And the balance is $2.11. Once they seize that, this matter will be over and done with. And you should then.
I'm not paying the $2. And it's disgusting that your court, they're using your court as a vehicle to steal money from people, especially when they're charging unknown fees for no reason. The money that is taken out of my check in the last 2 months is more than the original balance.
That's probably true. There's been interest.
Anyway, they're charging garnishment fees on top of it. They charge garnishment fees for a company I didn't even work for.
Well, they are entitled to charge a garnishment fee. Anyway, this thing's almost done. Mr. Sharp.
I'm not paying it.
Sounds like.
I'm not paying
all right,
it.
well.
I'm not.
Well, don't pay it. They'll seize it out of your income and then it'll be done.
I'm filing an ethics complaint against you with the Michigan Bar Association. I'm filing a complaint with the for an ethics violation for the attorney at Velo Law. Yeah, and I'm contacting Channel 3 that you allow these people to take more money than what is actually owed. There shouldn't be anything owed. I paid Central Professional Services. Premier Medical Care even says the balance is zero, that it has been paid.
Well,
and yet you're going to allow that.
It becomes zero when they just close the debt out and turn it over to a collection company. as far as they're concerned, it is zero. All right,
And the
Mr.
collection
Sharp,
company
you haven't
even
lost any of your edge since you moved to Fort Wayne. I wish you the best, and you could file whatever you like to, but you only owe $2.11.
and how do I owe $2.11 is my question.
Because the garnishment has covered everything but $2.11 of the debt.
How? Because my work has taken 25% of my check, should have paid it all off based on what the balance was when they started the garnishment, and what my company took out would have paid it off.
Mr. Meldy, can you speak to that?
All I can tell you, Your Honor, is we've only received the amount that I've stated on the record, the $243.46.
That's weird because the balance was, I've had 500 and something taken out of my check.
It doesn't mean that it's
For
all
this.
gone directly to us.
There's
So how's the
another account. There is another account on the $4,000 one, and I don't know what the status of that is, which I think may be where some of the confusion comes from.
No, I've already spoke to my payroll department. It all went to this account. I've had 500 and something dollars taken out of my check. Here, I can pull up my latest pay stub and I can give you the exact amount. Because the thing is I had a settlement check that was given to me in 2021. If I had known that this was an active balance, but I didn't because I was told that it was paid off, I would have paid this off back in 2021 because I received a sizable settlement after suing a former employer for violating federal law.
Well, just reviewing this file, you had another case, that other case that I referred to, which was in the thousands of dollars. In this case, the actual debt was $315. There were costs and attorney fees, and a judgment entered in July of 2018, the amount of $4,084.94. They filed for a writ of garnishment in October of this year for a unified distribution company. And at that time, the total amounts paid had been $210 with costs, including interest and costs. The amount due as of October 12th was $560.97. So
Correct,
you're
and that's how much
correct.
has been taken out of my check, $560.97.
All right, that's been garnished.
Correct. It's on
You
my
were
latest
looking-
pay.
Go ahead.
This is on my latest pay stub for this week. Garnishment writ 560.97.
All right, then they would have paid the debt as of October 12th, $2.11, maybe interest from there. If I were you, Mr. Meldy, I would not chase $2.11. Now, in the other case, 191788, you had a portfolio recovery associates case that you were making installment payments on. But this garnishment is on that old case from 2018. So yes, they did take 560, which was the amount in the garnishment, which you got notice of at Thompson Avenue, Fort Wayne, Indiana, as of October 12th. So you're right. Maybe you don't want to pay the last 211, and it's probably worth a lot more effort than it's worth for them to collect it. Anyway, I find that the objections are not valid, and the plaintiff may retain the garnishment in this account. All right, Mr. Sharp, best of luck to you.
For now, until they have to pay out for the Fair Debt Collection Practices Act violations.
All right, well, that's
But
fine.
I'm glad you allow them to use your court to steal money from people.
Well, I don't have to like it, but I have to follow the law. So you're free to go, sir. All right, Mr. Meldy, best of luck.
Thank you, Your Honor.